were supposed to have the representative of Rwanda joining us today. I'm not really sure what happened, so we couldn't be able to have that. This convening is taking place within the framework of the decision of the African Commission on Human and People's Rights in its resolution relating to the 1994 genocide against the Tutsi in Rwanda. It is to be recalled that both the African Union and the United Nations, through decisions of both organizations, have designated 7 April as the International Day for the commemoration of the genocide against the Tutsi in Rwanda. The period of commemoration actually runs from the 7th of April until June. And we in the Africa Commission on Human and People's Rights, since the adoption of that resolution, have on a yearly basis been commemorating the 1994 genocide against the Tutsi. And the purpose of this panel is first and foremost to ensure that the lessons from that horrific incident that shocked the conscience of the continent and the world are adequately heeded, and us at the African Commission on Human and People's Rights, we are convinced that the promotion and protection of human and people's rights is part and parcel of ensuring non-repetition of such kind of horrific acts on the African continent and indeed beyond. The other reason for the convening of the panel is also for purpose of advancing, not just in terms of the paying homage and respect to the lives lost, to the suffering endured by those who have been victimized and brutalized through that massacre in 1994. Indeed, that is very important. But also to ensure that there is increased consciousness and action towards ensuring that it's not just in Rwanda, but importantly, and of course beyond Rwanda, in all parts of the continent, that this thing doesn't occur. Since 1994, as you know, a lot of progress have been made, particularly institutionally and normatively speaking. We have witnessed the shift from the Organization of African Unity to the African Union. And one of the factors behind the institutional and legal change in the African Union is actually that experience from 1994. That is why Article 4H of the Constitutive Act stipulates that the African Union has the right to intervene in situations of grave circumstances, namely genocide, war crimes, crimes against humanity. And the AU also established institutions for dealing with and operationalizing these normative commitments, including the Peace and Security Council of the African Union. And at the level of the Commission, we have also played our part through the advancement of normative and institutional developments, through the study on human rights in conflict situations, through the study on transitional justice and human and people's rights in Africa, and indeed through the various advocacy work and engagement that we have had. Most recently, the AU Commission also established the Office of the Special Envoy for the Prevention of Genocide and Mass Atrocities. So a lot of progress have been made, normatively and institutionally. But the stark reality of our current situation and what we have experienced over the course of the past years is that there is an increasing gulf and divide between the progress that have been made normatively and structurally and the actual realities of people who are caught up in the crossfire of violence on the continent. You might have heard the chairperson of the Commission in his opening remarks making reference to some situations in which genocidal violence might have occurred. And the question really is, if you look back, for example, if we take the case of Sudan, if you look back to 2004 and 2005 and 6 around Darfur, the level of political, social mobilization against the horrific incidents that were unfolding in Darfur was incredible. We have been having a lot of media coverage of what was happening. Countries both in Africa and elsewhere in the world, civil society organizations, the level of activism, engagement, and mobilization and political action has been really huge. We have experienced muted responses to heinous acts of mass atrocities being perpetrated, particularly in conflict situations on this continent. So what happened? What have we become? Have we become numb? And why do we have the difference between these institutional and structural advancements on the one hand, but the political sense of outrage, the social outrage that we have displayed some years, about 20 years ago? What happened to that? Why are we not as outraged, even more outraged today than we were 20 years ago, for example? What happened? The plight of people in Sudan, in Eastern DRC, in the Sahel. Why? It is exactly for this reason that the best way that we find to pay homage and respect to those who lost their lives in 1994 is actually to ask these difficult questions. Because we are indeed failing. Something is not adding up. How can we have this increased gulf between the normative and institutional advancements and our sense of outrage in the face of such violations? To help us reflect on all of these issues, I'm very pleased that I'm joined by the two distinguished gentlemen that I introduced earlier on. Maybe we can start with the Special Envoy of the Chairperson of the African Union Commission for the Prevention of Genocide and Mass Atrocities, Adama Deng. Colleagues can you please?
Your Excellency, Professor Renengo Lungu, President of the African Commission on Women and People's Rights, honorable commissioners, representatives of the civil society, ladies and gentlemen.
We can't hear.
I will start by Your Excellency, Professor Renengo Lungu, President of the African Commission on Women and People's Rights, honorable commissioners, representatives of the civil society. I will start by calling the government giving a commendation to democratic reforms organized by the African Union.
Should move near his microphone.
When we pay our respects to the victims of the 1994 genocide perpetrated against the Tutsis in Rwanda, we should be looking back, but we should
Okay, colleagues, can you do something about it? We'll come back to that because you check and properly do the necessary check before we proceed. Instead of wasting time, I will move to Alan and then we'll come back to that. Please. Where is Alan? Okay, Alan, please.
Thank you, Commissioner Derso, and good afternoon, ladies and gentlemen, honorable commissioners, distinguished delegates. 31 years ago, the 1994 genocide against the Tutsi in Rwanda exposed catastrophic action, cost of inaction, and deadly consequences of silence in the face of rising hate and mass violence. Nearly 1 million people lost their lives in just over 100 days, an atrocity that unfolded not in darkness, but in full view of a world that chose not to act. This genocide was not only a failure of humanity, it was a failure of our regional and international protection systems. Today we remember the victims and the survivors, but remembrance alone is not enough. Our duty as the African Commission on Human and People's Rights, as organs of the African Union, as member states, as national human rights institutions, and as civil society, is to ensure that our collective never again becomes a lived reality, not a hollow refrain. The African Union Transitional Justice Policy offers us a transformative and homegrown framework rooted in African values and international norms. It emphasizes a holistic, victim-centered, and rights-based approach to justice, truth, accountability, reparations, and guarantees for non-repetition. The policy underscores the importance of institutional reform and civic trust, pillars that must underpin all post-conflict situations, recovery, and atrocity prevention efforts. However, for these commitments to translate into prevention, three things are essential: principal leadership from this Commission, national ownership by states and institutions, and strong partnerships with civil society. In the spirit of the African Union Transitional Justice Policy, I wish to make three key recommendations to this Commission, to the African Union Peace and Security Council, to member states, and to national human rights institutions present. First, the Commission should further integrate transitional justice into its prevention mandate. Through its study that Commissioner Derso mentioned just now on transitional justice and human and people's rights in Africa, and through the Resolution 486, this Commission has laid important normative foundations. But these should now be operationalized, and this is how we suggest the operationalization. One, systematically deploying early warning and investigative missions in contexts showing signs of identity-based violence, hate speech, and institutional breakdown, as we see today in Sudan and Eastern DRC. Second, appointing a dedicated focal point or a working group on genocide prevention and transitional justice within the Commission with a strong survivor-centric lens. Third, to issue country-specific guidance on transitional justice obligations under the African Charter. Such an opportunity presently exists for Sudan in the ongoing work of the fact-finding mission of this Commission on Sudan. And finally, strengthening partnerships with local truth-telling and memorialization initiatives that promote social healing and counter revisionism and denialism. Civil society is ready to support these efforts with documentation, with research, with survivor engagement, and on-the-ground analysis. The second point is that there should be institutionalized and sustained coordination between this Commission and the African Union Peace and Security Council. As civil society, we have often witnessed warning signs years before violence erupts. but too often these warning signs go unheeded due to institutional silos. The African Charter and the PSC Protocol provide clear basis for complementarity. And in this regard, we would need a formal mechanism for information sharing between this Commission and the PSC on early warning indicators, especially in conflict-affected states. Joint missions and briefings to the PSC by this Commission, particularly where rights violations signal potential atrocity risks. Third, inclusion of civil society evidence and survivor testimony in conflict assessments and peace missions. Integration of human rights risk assessments into missions and mediation efforts, ensuring that prevention is not seen just as a post-conflict exercise, but a tool for averting escalation. And then finally, in this segment is a permanent liaison role between this Commission and the AU Special Envoy on the Prevention of Genocide and Other Mass Atrocities. Without coordination, prevention becomes reactive, but with cooperation, we can turn early warning into early action. The third and final one, Honorable Commissioners, is we must ensure enhanced national implementation of transitional justice measures, particularly legislative, institutional, and educational reforms. Prevention begins at the national level, but the best prevention is investment in justice and inclusion. We encourage member states present to adopt national transitional justice strategies aligned with the African Union Transitional Justice Policy and the African Charter. We urge legislative reforms to criminalize hate speech, incitement to violence in accordance with human rights standards. We request for to support the integration of genocide prevention and human rights education into national school curricula with survivor testimonies at the center. And finally, to amplify the voices and rights of survivors, not only as witnesses to the past, but as architects of the future. National human rights institutions have a crucial role to play here, monitoring risks, advocating for policy change, and serving as bridges between the state and society. We urge national human rights institutions to adopt genocide prevention as part of their strategic mandates and to collaborate closely with local organizations and survivor communities. So as we commemorate, let us remember that transitional justice is not a linear process. It's a long journey, and prevention is not merely an aspiration, it must be our practice. The Commission has a critical role to play in ensuring that the rights enshrined in the African Charter not only are respected in times of peace, but are fiercely protected when they are most at risk. Let us honor the victims of the 1994 genocide against the Tutsi with more than just words, with action rooted in justice, grounded in dignity, and guided by the painful but powerful lessons of our past. Thank you for your attention.
Thank you very much, Alan, for that very probing and powerful intervention, highlighting the specific actions that is expected of us at the African Commission on Human and People's Rights, working in concert with the various institutions of the African Union, from the Peace and Security Council to the Special Envoy on the prevention of genocide and other mass atrocities. That brings me to the message from Adam Adeng, the Special Envoy. The reason why we regularly interact with him and engage him and have him in this occasion is exactly to start practicing that. Thank you very much, point well taken, and we will have your intervention for informing the follow-up action that we need to do. Colleagues, please.
Your Excellency, Professor Renengo Lumbu, President of the African Commission on Human and People's Rights, Honorable Commissioners, representatives of the civil society, ladies and gentlemen. I will start by recalling the point I made during the commemoration of Kivuka 31, organized by the African Union, AU, in Addis Ababa a month ago. When we pay our respects to the victims of the 1994 genocide perpetrated against the Tutsis in Rwanda, we should be looking back, but we should also be looking forward. Such terrible events have lessons to teach us, and by learning from them, we are honoring those who died. We have a responsibility to do everything in our power to prevent these crimes from happening again. The commitment not to forget and the commitment to prevent are two sides of the same coin. As I always stress it, the genocide against the Tutsis in Rwanda was witnessed by the international community that made the unspeakable choice of not intervening to prevent or stop it. This was evidenced in the report of the International Panel of the Eminent Personalities established in 1998 by the Organization of African Unity, OAU, to investigate the 1994 genocide in Rwanda and the surrounding events. I had the privilege to sit and chair the editorial committee which reviewed the final draft of the report. The IPEP visited the ICTR in Arusha, where it was briefed on the tribunal's operations. It's worth to recall that the OAU asked the panel to establish the facts about how such a grievous crime was conceived, planned, and executed, to look at the failure to enforce the United Nations Genocide Convention in Rwanda and in the Great Lake region, and to recommend measures aimed at redressing the consequences of the genocide and at preventing any possible recurrence of such a crime. The panel was also mandated to investigate what African and non-African leaders, individually or collectively, could have done to avert the genocide. There was no doubt that in Rwanda the UN failed the Tutsi. The Organization of African Unity also failed the Tutsi. We cannot ignore that there are lessons learned from the our failure of the past. It's no surprise that I'm mentioning at the very beginning of my remarks the visit of the IPED, as it shows what I consider a key lesson drawn from the genocide against the Tutsi, a key lesson that relates to the accountability for past crimes. Indeed, the work of ICTR has demonstrated that no matter the position of perpetrators, accountability can significantly contribute to healing and national building. Further, worth noting that accountability isn't limited to international or regional courts or any other specific judicial processes. All that is required is the sincere commitment of the society to grapple with its past by bringing those most responsible to account. But the process can also serve as a powerful reminder that no matter your position, decisions must and should be guided by values of rule of law and human rights. Drawing lessons on the failure of the OAU, the AU demonstrated in its constitutive act a critical shift from the principle of non-interference in the affairs of states to one of non-interference to the suffering of the earth. These principles AU the right to intervene in grave circumstances, namely war crime, genocide, and crimes against humanity. Over the past decades, my personal and professional background has thrown me in the global conversation on genocide prevention and vigilance. My humble contributions stem from legal expertise, human rights advocacy, and direct involvement in international justice. Today, I humbly serve as the inaugural AU Special Envoy on the prevention of genocide and other mass atrocities. I'm therefore always reminded that genocide prevention requires legal accountability, international vigilance, and proactive intervention. Beyond the lessons we must learn from the 1994 genocide against the moments in Africa that make the work and vigilance of the African Commission on Human and People's Rights, ACHPR, and the AU particularly urgent today. Several African countries are currently facing political crisis and armed conflict, resulting in massive human rights violations. For example, beside what has been going on in Eastern DRC, the situation in Sudan and South Sudan, the attacks against the dignity of sub-Saharan migrants in North Africa and notably in Tunisia and Libya requires urgent attention to prevent atrocities and protect vulnerable populations. Furthermore, the spread of hate speech and discrimination, often exacerbated by ethnic, pose a serious risk of violence and genocide. It is crucial to monitor and counter those discourses to avoid tragedies like those of the past. Moreover, conflict and political crises lead to massive population displacement, creating critical humanitarian situations. The ACHPR and the AU must work together to provide adequate protection and assistance to refugees and displaced persons. These developments truly underscore the importance of heightened vigilance and rapid intervention. Ladies and gentlemen, while repeating that the ACHPR and the AU should increase their vigilance to prevent such atrocities in the future, it is worth noting certainly significant frustration with the international community's handling of the Sudan and South Sudan issues, the Peace and Security Council's statements on this crisis notwithstanding. The killings of the Masaliks in Darfur, allegedly targeted because of their identity, the rise in hate speech targeting the Nuer in South Sudan, particularly the gendered dimension of this hatred, is worrying. The international community, including the ACHPR, must be prepared to intervene quickly if there are signs of genocide or massive human rights violations. In addition to the accountability I already mentioned, there are also other lessons to be learned from the 1994 genocide against the Tutsi. Allow me to refer to some of them in a telegraphic manner of time constraint. Reconciliation through truth-telling commissions. This is an important process in ensuring that victims can face their tormentors. Again, Rwanda has demonstrated that this process can even be homegrown initiatives with sincere commitment to address the root causes of the conflict. Contribution to legal and institutional governance of the country. Such efforts significantly increase capabilities of national institutions to address rule of law challenges in the country. Again, the support of ICTR to national institutions of accountability stands out. For the ACHPR, one of its key strengths is its investigative mandate. This is an area that could be strengthened to allow or enable the institution's sound and alarm of ongoing or potential violations of human rights. It has ability to bring these issues to the attention of the member states. The ACHPR has an advantage of being an African institution without baggage of being called out as an imposition of external actors. It should utilize this opportunity of being an institution created by African states to report on potential threats and challenges to member states. Its ability to work with civil society should be strengthened. This aspect recognizes the indispensable importance of civil society in reporting and bringing to light potential threats and violations. Lastly, existing relationship between the ACHPR and the African Court on Women and People's Rights should be strengthened to address the issues related to accountability for human rights violations, as in the process this can help nurture rule of law development in the country in quest. Through education and awareness raising, we must address the danger of hate speech and discrimination, as this is crucial to preventing conflict, and also we have to be monitoring and reporting mechanism to effectively detect and respond to human rights violations. The crisis in Sudan and South Sudan particularly require a proactive and coordinated approach. This should apply also to the situation I referred in North Africa. Further, working closely with local organizations and community leaders will help identify potential tensions and risks. This will allow for the implementation of locally appropriate solutions and strengthen community resilience. Underscoring the importance of prevention and vigilance, it should be emphasized that the genocides against the Tutsi was not a spontaneous event, but rather premeditated and fueled by hate speech. This reminds the HCHPR of the need to monitor the warning signs of violence and strengthen prevention mechanisms. Another lesson is that media propaganda played a key role in the radicalization and dehumanization of victims. The HCHPR must therefore promote human rights education and combat hate speech online and in the media, mainly as social networks show how fast they can be these days. Furthermore, the responsibility of the international community cannot be overemphasized. The international community's inaction in the face of massacres in Rwanda was a moral and political failure. In 2025, this underscored the importance for the ACHPR and the AU to strengthen protection and rapid response mechanisms. This is fundamental. The genocide against the Tutsi also showed that international justice alone is not enough. The ACHPR must encourage processes of reconciliation and remembrance to prevent a repetition of such atrocities. Let us also reaffirm that refusing to acknowledge crime hinders the healing of survivors and delays reconciliation. The ACHPR must therefore ensure that the memory of the genocide is preserved and taught. These lessons are essential for the ACHPR to better fulfill its mandate and honor the victims of yesterday by preventing another genocide in the future. I thank you.
We thank the Special Envoy on the prevention of genocide and other mass atrocities for that very profound statement, calling on all of us to be vigilant, but also, importantly, on the necessity and imperative of accountability as one of the areas of lessons learned, on top of the prevention dimension that Alan also made reference to in his intervention. This brings us to the end of the presentations from the members of the panel. I now open the floor for interventions and reflections from members and delegates of states parties, NHRIs and member states, civil society organizations. I see the representative of Sahrawi Arab Republic. You have the floor, please.
Thank you very much, Mr. Moderator. Honorable Commissioners, Ambassadors, and delegates, all protocols observed. I just wanted to confirm that the Sahrawi Republic stands in unconditional solidarity with the victims of the genocide that occurred in Rwanda in 1994. That crime is still heavy and difficult to grasp for all of us, but we believe now that we are looking back to that sad crime as history, that we should never forget that without permanent attention, monitoring, promotion, and protection of human rights, we may likely witness new human rights violations, new crimes of war, crimes against humanity and genocide, all of which may always occur worldwide, not only in Africa, unless we make sure that to restore peace and establish stability based on the respect of African and international law. The genocide in Rwanda taught us, and I will finish, that neutrality cannot be a good choice, never. Never in the face of ongoing crimes and people's rights, and that impunity also of perpetrators can never be eternal. There will always be time for accountability, and history in the end will judge all actors, victims and perpetrators, but also passive witnesses and accomplices. Thank you very much.
Thank you very much, Sahrawi. Any other? South Sudan, you have the floor, please.
Thank you very much for giving South Sudan this opportunity to make some comments on the transitional justice package, the transitional justice policy for African countries. And I believe up to now, this policy is not been made public to many countries. The only countries who are able to know about it are those who are currently trying to implement some of the transitional justice situations in their countries, like South Sudan. I think, and I'm suggesting that the African Union Commission should help the member states to understand how these policies are going to improve the human rights situations in their countries. Because without that knowledge, it is very difficult for them to implement. Secondly, I would even want to take it further that this policy should be made as part of the curriculums in some of the institutions so that people know exactly how transitional justice works. Because I have heard from some people when I talk to them about the transitional justice in the current situation where we are trying to implement, they don't get it. It's very difficult. So that's something that I just want to bring to the notice of the Commission to start thinking on how the member state can be helped to understand the transitional justice policy. Thank you.
Thank you very much, South Sudan. Any other requests for the floor? Okay, I don't see any requests for the floor. Thank you for those two contributions. I would now turn back to Alan for any feedback that you have, any further reflections you have, and final thoughts, Alan.
Thank you very much, Commissioner Derso, and thank you for the comments that came from the Sahrawi Arab Republic, Democratic Republic, and South Sudan. I think the point that was being raised by the delegate from South Sudan, the ambassador from South Sudan, is quite strong in the sense that African Union member states should really take into consideration within national curricula. I had mentioned legislative and institutional learning around the African Union Transitional Justice Policy, the AU Department of Political Affairs, Peace and Security works with member states to try and assist member states to integrate transitional justice within not just their national legislation, but actually implementing of it. And the reality is that in many African countries, we need to deal and reckon with the past, whether that past is past that relates to colonial crimes, colonialism, or even human rights violations that happened post-independence. And so the policy framework remains quite an important document for states to reflect on and ensure that there's an implementation of it. The policy has 11 elements. The study that this commission has done expounds on each of these 11 elements, and it is worth you to have a look at this, and as you take your report back to capitals based on this session, integrating this specific issue of the 11 elements of transitional justice in the feedback to capitals would be really a step forward to raise the awareness on the policy and the frameworks and assistance, technical assistance that is available through the Department of Political Affairs, Business Security. Thank you.
Thank you very much, Alan. The message from the panel and from the interventions is clear. We are in a moment of crisis. We observe annually this commemoration, but this has become a routine that doesn't really trigger the kind of action, the kind of mobilization that is necessary in order to translate this commemoration and our commitment for never again into practice. The propositions that have been made by both Alan and Adama Deng are that for the African Commission on Human and People's Rights, first and foremost, to be at the forefront of advancing early warning through the various mechanisms that are at its disposal, including the issuance of statements, the issuance of urgent letters of appeal, through undertaking investigation missions, as the one that the Commission is currently doing with respect to the situation in Sudan, and through bringing to the attention of relevant bodies in the African Union, most notably the African Union Peace and Security Council, the issues that deserve the collective action of the African Union. The other point from the interventions is the need for implementation of accountability mechanisms. That without accountability, we couldn't properly integrate the lessons from the 1994 genocide against the Tutsi into our practice. Accountability is a prerequisite for justice. It is a prerequisite for creating conditions for preventing the recurrence of violations. And the African Commission on Human and People's Rights, as part of the discharge of its mandate on the promotion of human and people's rights under the African Charter, has contributed to the development of the African Union Transitional Justice Policy through the study that the Commission itself had adopted. And the implementation of Transitional Justice Policy expands the conception of accountability beyond and above prosecution and criminal trial. It avails states contending with atrocities and massive violations of human rights a wide range of options in order to establish the facts and circumstances around the occurrence of those mass human rights violations. How did they happen? Why did they happen? And who are the victims and who are the actors responsible? And also to identify ways and means of healing the wounds and the suffering endured by victims, and for ensuring that those who engaged in the perpetration repent for the acts that they have committed, and that the necessary reforms, institutional, policy, legal, social, educational reforms are also instituted. And these are the range of options that these instruments put in place. And finally, there is the question of the here and now. From Sudan, as mentioned earlier on, in the Horn of Africa, beyond Sudan, in other sites of violence, in Eastern DRC, in the Sahel, and Adama mentioned the plight of African migrants in North Africa. These need to concern and preoccupy us. And the actions that we take, or the neutrality, as the Sahrawi Arab Republic representative mentioned, or the neutrality and the silence that we choose, defines whether or not we are committed to what we are saying, whether we are willing to walk the talk. So what is it that we in this commission and this human rights community are willing and able to do in response to and to address these issues in Sudan, South Sudan, the Sahel, Eastern DRC, and the plight of African migrants in North Africa? What is it that we are willing to do? These are the questions that I would like to leave you with, and I wish to thank members of the panel, each of you, for your kind attention, and for those of you who took the floor for your contribution. I wish to thank all of you members of the Commission and the Secretariat for making this panel possible. Chair, over to you.